Hello, everyone. This is Tom Fox, back for another episode in our series on the failure to prevent fraud offense for the new economic, or not the new, but amending to the Economic Crime and Transparency Act. Today, I'm thrilled to have James Tillen, member at Miller and Chevalier. James, first of all, welcome back.
Thank you. It's good to be back.
James, we're typically talking about the FTPF or perhaps Latin America or a wide variety of other topics you and your colleagues handle. But today, I wanted to go across the pond, but have an American lawyer's perspective on the failure to prevent fraud offense. And what I really want to try to communicate to an American audience, as opposed to United Kingdom or other audiences, hey guys, if you're a multinational and you're doing business in the EU and the UK, you need to pay attention to this. And there may be things you need to tweak. There may be things you need to do. You may need to document in different ways. So I really just wanted to visit with you and ask, what are you and or how are you and your colleagues counseling clients? What types of questions you're fielding? And maybe start with internally at the firm, how are you approaching the failure to prevent fraud offense?
Yeah, it's yet another compliance regime that an integrated compliance program should address. So you have your corruption, your sanctions, your money laundering. Now we have cartels coming out of the U.S. and fraud is something that I think people inherently think is part of their compliance program, but not in the sense and in the detail that is required to avail yourself of the defense under the ECCTA. And so we've been advising companies that this is something to add to your risk assessment. This is something to consider where you figure out where you have gaps, where you can enhance your processes, procedures, training, communications, etc., because it is unique. Yes, you may have some elements already in place, but it's important to do that risk assessment.
James, I think it was interesting the way you framed your opening remarks, because if a company is big enough to have a department that worries about fraud, typically someone like me will go, oh yeah, that's the fraud guys. They're down the hall or they're in the basement and they're keeping people from stealing money from us. They do a great job. Just let them do what they do. And they don't think about what you said, which is integrating it into your overall compliance portfolio. Could you maybe focus on that a little bit? And do we misconceive the fraud part as something different, or are we just not thinking about it enough?
I think when you talk about addressing fraud within a company, typically the thought is protecting the company from fraud, from people committing fraud against the company, from employees, from outsiders committing fraud against the company. But here it's the company and its associated persons, which is very broadly defined, committing fraud to benefit the company. And so that's where I think that risk is not realized, not identified when fraud is part of a ERM process, a risk assessment process. It's not that type of fraud. And the integrated approach is, since associated persons, which can include employees, agents, subsidiaries, but also any service provider that's acting for on behalf of that company can create risk, then you should be then integrating that approach into your due diligence that you use for corruption or sanctions or money laundering or what have you. And so integrating it into that, integrating it into your communications. Yes, under a compliance program and under the DOJ evaluation of corporate compliance program, they talk about how there should be a tone from the top on these issues, tone from the middle on compliance programs. But it doesn't get into the specific detail of saying, which the guidance in the UK does, about actually saying explicit things about preventing fraud, avoiding fraud, that we're happy to take a loss to avoid fraud, that you should be reporting fraud, that you'll face discipline for fraud. And so those are the kind of details that your program might be missing. And you want that program, it's not like you have to invent a new program here for fraud, but it should be integrated into your existing controls.
James, you and or the firm have been very good at reporting through client alerts and other memorandum made public about the failure to prevent fraud offense, which you started literally a year ago, and then you reported on the details as the United Kingdom Ministry of Justice issued guidance back in November, and you reported on it also in your, I think, winter and spring reviews of the FCPA, noting it was coming. It's here. In 2 weeks, it's here.
2 weeks, exactly.
How would you counsel a company to consider or think about a fraud risk assessment, given they're probably very good at trying to prevent employees from stealing money, but they may not have focused on the associated persons component?
And this is where that guidance from the UK Home Office is very helpful, because it gets into quite a level of detail that's beyond what the DOJ ECCP has in it. And it talks about the different typologies and that corporations should be considering, and using the fraud triangle of opportunity, motivation, rationalization to first identify where you have associated persons, and then considering how those associated persons could create risk for you. Where are they incentivized to commit fraud for the benefit of the company? What's the motivation? How do they rationalize it? And then develop the policies and procedures to address those risks. And it gets into even thinking about the mental health of your employees, your compensation process, your incentive process, also how these associated persons could act in an emergency situation, such as like a COVID situation. So it really has a lot of detail that I don't think many companies have fully embraced if they're not in the UK headquartered company and been hearing this on a day in and day out basis. And yet the jurisdictional scope of this law is such that everyone really has exposure, because it would be very easy to have a victim in the UK, which could generate jurisdiction for the SFO to bring an action. The jurisdiction is quite broad here. That's why I think I'm glad you're focusing on this, because I don't think U.S. companies have that grasp of how far reaching the law is and the expectations they have for a compliance program.
James, one of the things I've heard you and your colleagues consistently counsel over this many years has been the cross-functional collaboration a compliance professional needs to engage in. It's not just looking at your navel and or your compliance program. It's bringing in others within your organization. Obviously, outside experts can help, but literally you need to have cross-functional collaboration inside your organization. Who could a compliance professional go to inside of an organization to help them think through the risks that you have articulated that are outlined in the failure to prevent fraud offense?
A lot of functions. And so I think you're thinking about, on your employee side, your HR policies and procedures, your compensation processes, the functions that's involved in that. You're looking at your supply chain team, because they're involved in the onboarding and oversight of these service providers that could create risk. Your finance team, on how they are monitoring and testing and the controls that are in place to prevent fraud, including how those controls cascade down to your subsidiaries that could create risk for you. Your legal regulatory teams. I think it's something that permeates all parts of the company, given how this fraud risk can easily be engaged in, including, for example, like advertising, the marketing side of the company, the folks that are responsible for your annual reports, because of the fact that misstatements could create a fraud issue to your shareholders. And so there really is something where it is so many functions that are impacted by this fraud risk. It's much more broad than, say, a corruption analysis, because of how fraud can happen in any part of the company.
James, I had a question posed to me, and frankly, I've been saving it up to ask you. And it was essentially, my client has a contract with a larger corporation, and there may have been fraudulent payments made. Does that invoke the failure to prevent fraud offense for the company they did the contract for?
Yes, it could, if that service provider is acting on behalf of the company, and it's for the benefit, and that fraud is for the benefit of the company. It doesn't have to be, the sole intent doesn't have to be to benefit the company. If, for example, an employee is engaging in fraud to increase their chances of getting a bonus, if that nonetheless that fraud benefits the company, that can violate the law. So the service providers are a huge risk to companies, And it's something that where I think US companies, US suppliers are going to run up against and see more frequently compliance language in contracts that require them to comply with the ECCTA. And so it's not something you should sign on to blindly. You need to understand what your obligations are. And so that's another way that US corporations, US based companies can be pulled into the ambit of the ECCTA is through these compliance measures that UK companies are going to be introducing because of the law.
James, as I grew up professionally in the energy industry, and of
Right.
course, every energy company has a UK presence because of the North Sea. So we were
Right.
very aware of things such as the UK Bribery Act and other UK legislation that we had to specifically adhere to. I am starting to see UK companies put in a compliance clause around the failure to prevent fraud offense
Mm-hmm.
and require compliance by US companies to satisfy the UK company's obligations. Is that an area that you would think you would see a little bit more of as UK companies start to demand their subcontractors, at least their first tier subcontractors, comply with the failure to prevent fraud offense?
Absolutely. Absolutely. I think it's something that's called out in the guidance. I've seen a lot of the UK law firms in their alerts are advising companies is like one of the first levels is that make that part of the compliance language for contracts. And so I think we can expect it just to be continue to cascade down and be something that's just a standard part of every contract now, along with UK Bribery Act, FCPA type language.
James, you touched on jurisdiction, and I want to explore that for U.S. companies because it strikes me that the jurisdictional aspect of this it may actually be broader than the FCPA. In other words, the
Yes.
whole world. Could you say a few words about what is the jurisdiction of the SFO or other UK authorities to prosecute under this?
Sure. Yeah, absolutely. So as I understand it, all it requires is that an act takes place in the UK or that there's a loss, gain, or victim in the UK resulting from that act. So that all requires is a UK victim. So, for example, a UK shareholder could be a victim. Now, there does require that one of the fraud laws at issue be violated, but those are very broad laws. There's false accounting, there's false statements, fraudulent trading, fraud by false representation, fraud by failing to disclose information, obtaining services dishonestly. There's these very broad, the Fraud Act, and as well as predecessor laws that are covered by this act and brought in within it. And yes, you have to violate one of those laws, but the connection to the UK is very broad.
The U.S. companies that Miller and Miller Chevalier are counseling, is it a wide variety of different types, meaning not simply energy, but you name the company, commercial, pharma, tech, all of these companies are really being forced to face this new law?
Yeah, absolutely. It's because of the UK such an important market for so many multinationals. Almost every company has exposure unless they have a very limited international footprint. But that's something that the risk assessment needs to take into account right away. What are your touch points with the UK?
James, as I said at the start of this podcast, one of the reasons I wanted to have you on to talk about this is to try to get the message to U.S. companies. Are you beginning to see them understand, hey, we at least need to start asking questions, or is it still really a nascent learning phase?
I fear it's still nascent, and I fear that because there's been so much upheaval in the US in the white collar world that other things have grabbed their attention, such as cartels, trade of tariff evasion, and other sort of issues of the day, and what's happening with the FCPA. And so they're running around with a hair on fire because of what the tariff situation is. And so they may have lost sight of this, particularly since I think there was in November 2024, when the guidance came out, that was a lot of attention and people may have started turning towards it. But by January, when things started happening with executive orders, it may have fallen down the list. But given that it comes into effect September 1st, and the SFO is itching to use it, they've made a lot of pronouncements about how they see it as such an important weapon for them now. And UK companies have stepped up in anticipation of September 1st. I think if you're on the back foot now, it's time to devote some energy to it.
James, we talked about the risk assessment and indeed the entire risk management protocol that you would go through. Can a compliance professional use that framework to work through these issues, or do they need to come up with something new?
I think luckily the language and the concepts that are in the UK guidance are extremely similar to past UK guidance, such as for the UK Bribery Act, but also the DOJ's language in the evaluation of corporate compliance programs, and then their attachment C to FTPF resolutions. They've organized it around 6 principles, but they all marry up with the hallmarks of an effective compliance program under the U.S. concepts. Their 6 are top-level commitment, risk assessment, proportionate risk-based prevention procedures, due diligence, communication, including training and monitoring and review. And so you can see those concepts are all line up perfectly. And so there's nothing that new, but within that, it's that fraud specificity that programs may not have.
James, anything else that we need to communicate to a U.S. audience about the failure to prevent fraud offense?
Now is the time. Actually, the time was a year ago, but now is really the time that you need to start doing something and consider this, whether you're adequately addressing this fraud and particularly this associated person's risk, because that's obviously, again, it's the third parties that where you have less control that could create risk for you. And so focusing on that and working this into your training, your communications, all aspects of your program is so critically important right now.
James, unfortunately, we're near the end of our time for this episode, but before we leave, I wanted to ask you if our listeners wanted to connect with you, find out any more information on the Miller and Chevalier resources that are available on this topic, what would be the best place or places for them to go?
That would be our website, milchev.com, and just search this topic and you'll find our past alerts on it, or you can just reach out to me, Tillen at milchev.com, and I'd be happy to send those to you.
James, actually, we're going to link to those in the show notes. We'll give those resources to our listeners. I wanted to thank you again for jumping on this podcast. It's exactly what I wanted, and I look forward to continuing this conversation.
Thanks, Tom. It's been a pleasure.
Compliance Podcast Network. Start your mornings with daily compliance news, quick, sharp updates on the top compliance and ethics stories in under 5 minutes every morning in Compliance Podcast Network. Because compliance never sleeps. Need practical advice fast? Check out Compliance Tip of the Day. One actionable idea to level up your program. Short and sweet, every day on Compliance Podcast Network. Got 10 minutes? We've got the week's top 10 stories. 10 for 10 brings you the big compliance headlines. Fast, fun, and focused. Every Saturday on Compliance Podcast Network. And don't miss the Sunday Book Review, where compliance meets culture through must-read books and big ideas every Sunday in Compliance Podcast Network. Whether you're in the office, on a walk, or commuting, stay smart, stay ethical, stay tuned. Only on the Compliance Podcast Network. Available wherever you listen to podcasts.